I hear you. All right, sorry, I'll look around. All right, are you Chadwick Price?
Yes, sir.
All right. Go through that case. Case number 20 CR 29, State of Ohio versus Chadwick J. Price. Hearing is being conducted by Zoom due to the COVID issues in the jail and elsewhere. And Mr. Price is appearing by Zoom from the jail. His attorney is Catherine Packner, appearing by Zoom from her office, and appearing also from the prosecutor's office as Assistant Prosecutor King. The defendant was charged or was convicted of aggravated possession of methamphetamine, fifth-degree felony, based on control back July 1st, 2020. There was a notification filed on September 1st that he had violated the terms of his, September 10th, that he had violated the terms of his control. He was notified of that obligation by the magistrate while I was gone, and I was set today for hearing. And Ms. Hapner, you and your client both are agreeing to this matter being held by Zoom rather than in person.
We are, Your Honor.
You're agreeing with that, Mr. Price?
Yes, sir.
All right.
Yes, sir.
Now, Mr. Price, since we are not in court, you're not sitting right next to your attorney to ask questions. If you have any time that you feel you need to talk with her about anything, just let me know, and I can put you and her into a breakout room where the two of you can speak, just with no one else being able to see you here. Okay?
Yes, sir.
All right. Now, the defendant was alleged to have violated rules 2, 7, 13, 15 of the court's order of July the 1st, and the matter is set for hearing at this time. Now, Ms. Hapner, your client wishes to proceed with the evidentiary hearing.
No, Your Honor. I spoke with Mr. Price this morning, and he will admit that he did violate his probation. He did use illegal substances.
Right. Well, Mr. Price, let me review these because I actually haven't seen them before today. It alleges that you have violated Rule 2 that you failed to report since July 27, 2021. Rule 7 that on September 10, 2021, you were unable to provide a urine sample to jail as requested by an officer. The defendant admitted to using meth and THC since last report date with officer on July 27, 2021. Rule 13, defendant was referred to FRS counseling on June 22, 2021. Defendant only attended group on July 21, 2021. Defendant has been closed out due to non-compliance. June 22, 2021, the defendant is placed on call and drug testing by this officer. Defendant to call in each day to see to report that day. Defendant was not calling in and failed to show drug testing. Rule 15, on or about 9/10/21, you failed to pay court-imposed financial sanctions ordered by the court on July 1, 2020, and is currently in collection. So those are the allegations that are alleged to have been violated, Mr. Price. Now, you do have a right to have a hearing, which is the purpose of this hearing today, in which the state would have to, through the prosecutor, present evidence to prove to the court's satisfaction that you have committed these violations. You have a right to have your attorney cross-examine the witnesses presented by the state and bring out evidence that's helpful to your side of the case. You have a right to present evidence on your own behalf, to testify, to call witnesses, although you're not required to do so. Cannot be required to do so. In the event that you are found to have violated these conditions, one of three things can happen. I can continue community control of the same conditions, continue with additional conditions I think are appropriate. Or the third, the most serious, is that I could revoke your community control and sentence you to prison for 12 months and fine you $2,500. Now, do you understand? The the allegations that have been filed against you?
Yes, sir.
And you understand your possible consequences if you admit to these violations?
Yes, sir.
Has anyone promised you anything or threatened you in any way to get you to admit to these alleged violations?
No, sir.
All right, and do you have any questions you need to speak to your attorney about that?
No, Your Honor.
All right, then is it your decision to admit to the violations that I just read to you that were filed on September the 10th?
Yes, Your Honor.
All right. All right, anything from the state or the probation department regarding the disposition in this case?
Thank you, Your Honor. Given that this is the defendant's first community control violation, the state probation department would ask that he be continued on community control, ordered to complete residential treatment, and referred to drug court. Thank you.
Sandra?
Thank you, Your Honor. I did discuss that matter with Mr. Price this morning. It's my understanding that there is a bed date available for him this Thursday. So he indicated he is willing and ready to go to residential, and he's looking forward to drug court. So we do ask that you follow that recommendation.
What facility is your bed available? The Sturgill?
I'm gonna have to.
FRS Nasty House, sir.
Nasty House, okay. All right, Mr. Price, or anything you'd like to say?
No, sir, Your Honor. I just look forward to, if you go along with everything, getting back to where I was at before when I talked to you last year around this time.
There was originally a screening for Mr. Price back last year, and at that time he was doing so well. The second was he wasn't really necessary for drug court. Obviously, things didn't work out. Have you done a new assessment, Ms. Sturgill?
Yes, sir. I filed a letter on Monday
Yeah.
with a new recommendation.
All right. You mean yesterday?
Yes.
All right. I haven't seen it yet. Thank you. Did you bring it over to Ms.
Yes, I saw Dan put it in the file. Okay.
It's in the file. All right. All right. Let's see. All right. All right. Well, Mr. Price, I don't order people to go to drug court. They have to request it. You apply. I know it's your second go around. And you understand that this is voluntary on your part. If you admit to it, or if you wish to be admitted into it, and the court admits you that, it will be more intensive and there'll be more expected of you than what's been expected of you in the past. You understand that?
Yes, sir.
Now, I'll note this. Some of the things that you are going to be required to do in drug court, and put you in drug court, were already being ordered by the probation department. You were supposed to go into treatment. You did one day and dropped out. You were supposed to call in every day for drug testing. You didn't. And so those are things that are in drug court. So you need to understand that, that if I give you this shot, you've already failed once, so, you're not looking real good at this moment. I'm hoping that changes, but I am going to go ahead and do this, if that's what you want.
Yes, sir.
All right. All right, the court will admit the defendant into drug court, and will continue him in community control on the drug court docket with all the conditions of that docket. And in addition, your community control is going to be extended by 1 year, because that's a minimum of 18 to 24 months is what we're looking at, and I don't want to run into any issues of not having enough time for you to complete the program successfully. So we're going to extend this by 1 year, and then we'll pay additional costs. And you're to comply with all the terms of the drug court docket and the program description that Ms. Sturgill went over with you, plus have to successfully complete your treatment program at Massey House and aftercare as recommended by your treatment team. So you'll have to do whatever it is that they recommend, that's what you're going to do. Even if it's not mainly, again, Massey House isn't a lockdown facility, but I can tell you, if you walk away and don't successfully complete it, you come back here, the chances are you're going to go to prison. So, when we give you this break, the probation department's recommending that, the state's recommending it, and recommending it, and I think it's really an appropriate candidate for it. I think you can benefit from it if you're honest about it, and you really want to do this. So, that would be the order of the court. And that day is Thursday, is that correct? All right.
Yes, the
He's held in custody until the Bates massacre. All right, you have any questions, Mr. Price?
No, sir, just thank you to you and everybody else that's trying to help me along the way.
All right, well, we can thank you by being successful.
Yes, sir.
All right. Anything else from council?
No, Your Honor.
All right, thank you. Stevens, is that next?
Yes, sir.
Okay. All right, are you Joshua Stevens?
Yes, sir.
Joshua F. Stevens, all right. This is case number 20 CR 163, State of Ohio versus Joshua F. Stevens. Stevens is appearing by Zoom from the Justice Center due to the COVID-19 concerns at the jail, sheriff's office, and everywhere else. His attorney is Captain Hacker, appearing by Zoom from her office. Representing the state is Mr. King from his office by Zoom on the probation department. Mr. Stevens was convicted of breaking and entering and was placed into the drug court on October 9, 2020. And that's a breaking and entering was a felony, and I think he was also convicted of theft. Yes, and first degree misdemeanor. There was a warrant issued for Mr. Stevens' arrest due to being declared an absconder. He was taken into custody and was advised on November 15th of the alleged violations against him by the magistrate, and the matter was set to stay in hearing. All right. Now, Ms. Hafner, you and your client both sent to the hearing being conducted by Zoom rather than in person.
We do, Your Honor.
You're in agreement with that, Mr. Stevens?
Yes, sir.
All right. All right, the allegation alleges that you violated Rule 2 and on or about 10/26/20, you wrote a report to the probation department, and on 10/27/20, you failed to report as ordered. Rule 7, that on or about 10/26/20, the defendant called the officer admitted to bringing heroin back to the recovery council and using while at the recovery council. And then Rule 13, that on or about 10/29/20, the officer received a fax from recovery council stating he left treatment on 10/26 against staff compliance. So those are the allegations. Now, Ms. Hafner, is your client wishing to have the evidentiary hearing, or going to be some sort of admission?
Your Honor, he will admit to violating Rule number 7.
All right. Okay, well, we want to have evidence then on the other two violations. This is a drug court pocket case, so.
My understanding from Mr. King was that was the one he wanted admission to.
Okay, well, I mean, that's fine. If you want to admit to it, that's fine, but, if not admit to all of them, then we'll have a hearing. And I'll hear evidence on the other alleged violations. because this is I look at drug court violation a little bit differently than I do other. Yeah, so it's a package deal, so, you know, I want to know about all of them, so. Mr. King?
He admits to all of them. I guess it was just my understanding from Mr. King that he wanted the admissions number 7 and the other 2 would be dismissed. It's not a problem. I spoke with Mr. Stevens this morning, and he will admit to all of them.
Okay. All right, so, Mr. Stevens, you have a right to have a hearing on this matter, in which the state is required to present evidence that proves that you have violated these conditions. You have a right to have your attorney cross-examine the witnesses that the state presents, which would be the probation department, I assume. And that would be to try to bring out evidence to help your side of the case. You have a right to testify on your own behalf. You also have a right to present any other evidence of witnesses on your behalf, although you're not required to do so, either of those things. Now, if you admit to violation of these allegations, one of 3 things can happen. I can continue under community control in the drug court under the term previously ordered. I can continue with additional conditions that I think are appropriate on community control in drug court, possibly not in the drug court, but still on community control. Or the third, and the most serious, is I can revoke your community control, terminate you from the drug court docket, and sentence you to 12 months in prison on count 1 and 6 months in the county jail on count 2. Now, I meant to tell you at the beginning of this, and I didn't, that since we're not in courtroom or you're next to your client or your attorney, you would like to speak with her about anything before we go any further, or any time during this hearing, just tell me, and I will put you and her into a breakout room on the computer. That means it'll be just the 2 of you talking to each other. No one else will be able to see you or hear you, and you won't be recorded. You understand that?
Yes, sir.
Okay. Do you need to speak to Ms. Hackner about anything before we go on?
No, I talked to her earlier, so.
All right. So then, are you admitting or denying the allegations that were filed on the 15th of September that I just read to you?
I'm admitting to him.
All right. On behalf of the state, anything on behalf of the state probation department regarding Mr. Stevens?
Thank you, Your Honor. Mr. Stevens was placed on community control and entered into the drug court back on October 7th of 2020. And less than 3 weeks after that, he has just admitted that he took heroin into the recovery council, used heroin while there, left against staff advice, and perhaps most egregiously, his whereabouts have been unknown for nearly a year now. So based upon all that, it would be the position of the state as well as the probation department that this defendant was not amenable to community control and would ask that his community control be revoked and he be sentenced to a term of incarceration. Thank you.
All right, Ms. Hackner,
Thank you, Your Honor. Mr. Stevens informed me that he did sort of lose contact. However, he also informed me he has been clean for approximately 8 months. He had been living in Dayton. He has been to a sober living facility there and completed that and been clean for 8 months. There's also, my understanding from Ms. Sturgill, is that he has a bed available at STAR on October the 6th. So we would ask you to continue him on community control and have him complete the STAR program.
All right, Mr. Stevens, anything you would like to say regarding this?
I mean, I know I took off and ran. I mean, I got scared. I used drugs in the facility. I got scared. I ran for like an actual month, and I should have came in and turned myself in, but I've been up in Dayton. I completed Access Treatment Center. I have my mom should be getting a certificate to give to Tanya for it, and I went to a place called Marathon Medical. It's a sober living house. I had a job. I worked at Woodland Cemeteries up there, and I know I should have came and turned myself in. I'm sorry, sir. I just got scared.
All right. Anything else?
No, that'd be it.
All right. Well, drug court is for people who are high risk, which obviously you were and are. You had a 34-0 arrest score, which is extremely high. We had a number of previous convictions, at least two, let's see, two felony convictions and a number of misdemeanor convictions. And I'm just looking at after your served your prison term for your burglaries, you're on PRC, but I'll say this, that while you're incarcerated at ODRC, you have one of the worst write-up violation records I've ever seen. 1.5 full pages of 8.5 by 11 pages, single spaced violations from the time you were there in July 2012 until December 16th. Then, when you were on PRC, sanction on 1/15/15, 2/9/15, 6/11/15, 7/21/15, 12/21/15, 3/27/17, 1/11/18, 3/30/18, and when you were terminated, when you ran out of time, it was unsatisfactory. Unfavorable final release means that you didn't comply, but your time ran out. So then, you know, I admitted you in the drug court. You told me all the things that you thought I wanted to hear, which I do want to hear, but I want them to be sincere. I don't think they were. And you were there in like less than a month, using drugs, taking it back on your first pass apparently, or at least one of your early passes, and then leaving and running. And you know, you've gone for 11 months. And you know, whether or not you were sober or not during that period of time, we don't have any record of that, we have no proof of that. I know you weren't sober when you were in the treatment program, because you take drugs back. But you know, you left, you didn't keep in contact, made no effort to come in contact, and just basically said I'm off. And drug court requires a commitment. You made that commitment, but you didn't mean it. And there's no reason for me to believe that you mean it now. So the court is ordering that your community control in drug court be revoked, and you should be sentenced to the correctional reception center at Orion, Ohio, for a period of 11 months. And you're going to be given credit. You have 16 days total credit, 4 back in June of 20.
No, we can't hear you.
Okay, I'm sorry.
That's better.
4 days in 2020, 1 day in August of 2020, from 8/7, then again on 8/9 to 8/10, 2 days, and then 9/14 when you were arrested to 9/22, 9 days. So that'd be a total of 16 days of jail time credit. Now, upon completion of the prison term, Mr. Stevens, the Adult Parole Authority may, at their option, place you under what's called post-release control for a period of up to 3 years, meaning you can be supervised in the terms they set, as you're aware of since you've been on before. This time it's optional, not mandatory. And if they determine that you have failed to comply, then they can return you to prison. They can serve an additional period of up to 1/2 of the prison term that's been imposed by the court. But you committed a felony while under post-release control supervision, and then in addition, whatever sentence can be imposed in his case, that judge can also sentence you in this case to an additional period of 1 year, whatever time left on that 3 years of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, and if you fail to do that, then the clerk can collect that through various means, including levy on bank accounts, wage earnings, or other assets that you may have. If that doesn't collect it, then once you complete your prison term, not while in prison, once you complete it, the court, in order to do the service, give you credit for each hour you work, and an hour rate set by the court. And each hour you work will reduce your judgment by that amount before payment. All right, is there anything further with counsel?
No, Your Honor.
All right, you're remanded in custody, Mr. Stevens. Randy Switcher on the docket today? I don't have her file.
I don't believe so.
I think that they could not do her because, she's at ORW.
Oh, okay, all right.
I think it's October 6th or 8th instead.
Yeah, that was one we had to postpone bringing prisoners back, so, all right, so that was rescheduled, all right. So this should be Melissa, wait a minute, now what's your name, sir?
Rick Nichols.
That's not until 2:30, Judge.
Was it
Rick Nichols.
Rick Nichols?
We need
Is,
more.
the case, your attorney's Mr. Armitage, right?
Yes.
All right. What about Melissa Lambert, is she in custody?
She is not. I had trouble I couldn't get hold of her. She doesn't have a phone. She's homeless. She was staying with somebody in Hazard, Kentucky. So I couldn't get hold of her to let her know that it was today instead of tomorrow. I told Mrs. Ogier, who called me just before we started these hearings, that I think my client is going to plead in the morning in Fayette County. And if he does, that means I will be available to be here tomorrow afternoon for her as soon as she shows up tomorrow afternoon.
All right.
Because she did call last week to confirm the date of the retrial.
All right, so she wasn't aware of this retrial?
She was not.
Okay, all right, we'll just put this aside then until tomorrow.
Okay, thank you.
And then,
And of course, if I do go to trial tomorrow, I won't be available.
yeah, that's fine, we'll just have her come back in there today. We'll get another date that you're available. Now, let's see, we also are supposed to have Mr. Hill, who's at the Monday program.
Correct. I had a separate invite for him, so I don't know whether.
Yeah, I was gonna say, I think, we could do him at this point, for whatever reason, that, Ben was saying that they wanted to do it later.
Yes, sir.
Okay, so we gotta get an invite for that.
Must have at 2:30.
All right, let me go see what time it is. Do you know what time that is, Miss Hammond?
The invite said 1:30, but it was simply a separate invite from this one. So I don't know whether we need to log out, log in again, or how
Well,
that
let me look
works.
here. Yeah, I think we have to, I don't think I can. I don't think there's any way to run two at once. In fact, it kicks off. All right, so Andrewville is a separate line, time. Is he-
You said, right? He's on that one, right?
Oh, she said she got a separate one.
Oh, I just sent.
Oh, she just got a separate notice, but at the same time, all right,
I think.
Okay.
all right. Good.
Unless she, because they're waiting, but they're not in there.
Well, what do you want, can you contact them and
I
tell
mean,
them?
I've been talking to them, you out there waiting for you.
Right, well, go ahead and tell them to log in. So I don't have it logged in yet.
Let me make sure that I've got the, maybe it is a separate.
Well, no, I think it is separate because, yeah. No, it looks like it's the same one. Yeah. Got the same meeting ID and the same passcode, so they should be logging in. All right, well, we don't have a starter drive yet. So, Dan, you had to come over and check the, hold on. You know what, his are not actually scheduled till 2:30.
Yes, sir. 2:30.
So, never mind. Well, Mr. Nichols, your attorney's not, your hearing's not scheduled for another half hour, so I don't know what the officer wants to do, they wanna leave you there, or want you to go back yourself, or whatever they want to, how they want to handle it there. I'll be back with you guys about 25 minutes. All right, they're coming in. Okay, are you Andrew Hill on the screen that's labeled as T. Nisman?
Yes, Your Honor.
All right. It's case number 20 CR 37, State of Ohio versus Andrew Scott Hill. This hearing is being conducted by Zoom due to pandemic issues and Mr. Hill being in a treatment facility. His attorney is Catherine Hatcher. She's attorney from her office by Zoom. Attorney from the prosecutor's office by Zoom is Mr. King. Now, Ms. Hatcher, you and your client both agreed to conduct this hearing by Zoom remotely rather than in person in the courtroom.
Yes, Your Honor.
And you're in agreement with that, Mr. Hill?
Yes, Your Honor.
All right, thank you. Now, Mr. Hill, since we're not present in the court where you would be sitting next to your attorney normally, if at any time during this hearing you need to speak to her or have any questions you'd like to ask her about or anything, just tell me. I can put you and her into what's called a breakout room, which means you two will be the only two that are actually on
Recording in progress.
the screen. No one else will be able to hear you or see you, okay?
Okay.
All right. Now, Mr. Hill is charged with tampering with evidence and aggravated possession of methamphetamine, both third-degree felonies. And I don't recall when this matter set for trial, October 14th. This is a pre-trial scheduled originally for tomorrow, but moved up to today since Ms. Hatcher had a conflict in another court. And Mr. Hill, I've been presented with a copy of a plea agreement that has actually has original signatures, it looks like, of Ms. Collins and Ms. Hatcher, and a copy of your signature. So I'm going to hold this up to the camera, and first of all, if you recognize your case name and your case number there, and it says plead guilty, you've seen this form in.
Yes, Your Honor.
Okay, on page 3, there are signature lines, and after there's a full paragraph at the top, and then right below on page 3, there's a sentence that says, I enter this plea voluntarily. Right below there, there's a signature line for defendant, and it looks like there's a signature of Andrew Hill. So I'll hold that up to the camera, and is that your signature there under that statement?
Yes, Your Honor.
All right, good. Obviously, this is a copy. Did you sign this document and return it?
Yes, Your Honor.
Okay. Now, this agreement indicates that you're going to withdraw your not guilty plea and plead guilty to count 2, the aggravated possession of methamphetamine. Now, did you speak to your attorney about this? Were you able to speak with her about it before you signed this document?
Yes, Your Honor.
Yeah, I assume you signed this there at, where are you, what facility you're at?
The Monday program.
Okay, you signed it there at the Monday program?
Yes, Your Honor.
All right, but you were able to talk with her about it before you did so?
Yes, Your Honor.
Okay. And did you read this entire agreement before you signed it?
Yes.
You understand it?
Yes, Your Honor.
And are you entering into this agreement to plead guilty voluntarily?
Yes, Your Honor.
You feel you've had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And do you recall when you did sign this agreement?
It was 2 days ago.
Okay. All right. Now, as I said, the page 1 says you're going to plead guilty to count 2, the aggravated possession of methamphetamine under section 2925.11 revised code, third-degree felony. Further states that you understand that the maximum penalties for that could be up to 36 months in prison, that the prison term imposed, minimum will be 9, and there are different increments in between those 2 ranges. There's a fine available of up to $10,000 and a possible life suspension of 6 months to 5 years. Now, in this case, the prison term is not mandatory. It's presumed to be the correct sentence under the law, but it's not required. Do you understand that?
Yes, Your Honor.
Now, are you on community control now for a felony? Is that why you're in the Lundy program?
Yes, Your Honor.
And where's that from? Sure.
Montgomery County?
Okay. And are there any other felony charges that you're facing at this point?
No, Your Honor.
And other than that one charge there in Montgomery County, are you on probation, community control, parole, post-release control for any other offenses, felony offenses?
I'm on parole also.
On PRC?
Yeah, PRC.
Okay. And how much time do you have left on that?
I think like 516 days, something like that.
Okay.
It's also through Montgomery County as well.
All right. Now, the reason I ask is this. If you should be sentenced to prison in this case, and sentenced to prison from Montgomery County, those sentences could be ordered to be served consecutively to one another, meaning on top of each other or in addition to. You understand that?
Yes, Your Honor.
And also, since you're on post-release control supervision, if you are sentenced to prison in this case, or for that matter, the Montgomery County case, then the court could order you to serve an additional period for committing a new offense while under PRC to 1 year or whatever time left on the PRC, whichever is longer. In this case, you said you had 500 and some days, so that would be longer. And that would be, if that occurs, that is to be served, must be served consecutively to the sentence imposed in this case. You understand that?
Yes, Your Honor.
Right? Now, in this case, if you should be sentenced to prison, serve a prison term, once you complete the term, it's not mandatory to be put on post-release control, but it's optional, which means the parole authority will decide whether to do it or not. In whatever case you have right now, I don't know whether it's mandatory or optional, but in this case, it's optional. So they could decide to do it, they may not. That's up to them. The court has no involvement. If they do, you'll be supervised on the term set by the parole authority for a period of up to 3 years. And if during that time they decide that you have failed to comply, they can return you to prison for an additional period of up to 9 months for one violation, a maximum of half of whatever prison term was imposed in this case for one or more violations. That's the cap. But if you commit a new felony while under post-release control supervision, then in addition, whatever sentence can be imposed in that case, that judge could also sentence you in this case for committing that new violation while under PRC to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. You understand that?
Yes, Your Honor.
Now, I'm not required to sentence you to prison for this offense. I could impose what's called non-prison or community control sanctions, which is what everybody knows as probation. What that means is that instead of going to prison, you be put under the supervision of a probation department for a period of up to 5 years under the terms ordered by the court. Now, if during that period of time the probation department felt that you had not complied, they would have to file a written notice of that with the court, serve a copy of it upon you, and then you would be entitled to have a hearing and be represented by an attorney. And if the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your community control, then sentence you to 36 months in prison to fine you $10,000 and plus impose whatever PRC time would be available, or would still be remaining if over 1 year or under 1 year to 1 year consecutive. You understand that?
Yes, Your Honor.
Now, the charge in count 2 alleges that on or about December 8, 2019, in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, an amount equal to or exceeding 3 times bulk, less than 5 times bulk, in violation of Section 2925.11 of the Revised Code. So that's the charge. Again, it's a third-degree felony with the penalties I just described. Now, Mr. Hill, do you understand what it is you've been charged with in that indictment, what the state says you did, when, where, and how they alleged that you did it?
Yes, Your Honor.
You understand the possible penalties for that offense if convicted?
Yes, Your Honor.
Now, have you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible defenses you try to raise in trial, and possible outcomes of a trial with your attorney?
Yes, Your Honor.
And are you satisfied with your advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No, Your Honor.
On page 2, there are a couple of lines that are printed and underlined and printed in bold underline. I'll show that to you right there. You see that?
Yes, Your Honor.
Okay. There actually were two sentence paragraphs. One of them has been deleted or stricken out, meaning it doesn't apply. So I'm going to read you the one that's not stricken out. And it reads, defendant shall enter a plea of guilty to count 2, state will dismiss count 1. State defense jointly recommend committee control, and that defendant be referred to drug court. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement that you should be put under committee control or probation and be put in the drug court docket, that neither of those are binding upon the court. And so if you plead guilty, once I've heard all the information, if I decide that's not the appropriate sentence, you should get a prison term, I could sentence you between 9 and 36 months under the increments provided by statute. You understand that?
Yes, Your Honor.
Right? Now, do you hold any license or certificate from any state, board, or agency for any kind of a profession or occupation?
I'm OSHA certified to be a forklift operator.
Okay, and that's a federal licensing, I believe. And I'm not sure what happened. Under the law, we're required to notify any state agency that you have a license from. We're not required to notify the feds, but in the event that you're convicted, that might be the basis for some sort of action against your license by that agency. You understand that?
Yes, Your Honor.
Okay. Now, you have certain constitutional rights. You must understand before I can accept a plea of guilty from you. First, you have the right to have counsel. Ms. Hacker has been appointed as your attorney. She wasn't appointed simply to try to work the case out, but to provide any defense that might be available to you under the law that you'd like her to provide. So, if you decide you don't want to do this, that you want to defend against the case, she'll continue to represent you and defend you, including at trial, if that's what you want. Do you understand that?
Yes, Your Honor.
Right, now you have a right to a trial by jury on this case under the law, and what that means is that a jury would be selected of 12 persons from a group of people that are living in this county that are summoned for jury duty on your trial day. Once those 12 are selected, the evidence will be presented, they be instructed on the law, and then that jury would have to decide by an unanimous verdict, meaning all 12 have to agree to whether or not the state proves your guilt or proves beyond reasonable doubt. Now, if you decided you didn't want to do that, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you would have to hold a court or bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond reasonable doubt. You understand that?
Yes, Your Honor.
Under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that witnesses have to come in, testify in open court in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Under the Constitution and law, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have any witnesses you're not certain are going to come in voluntarily, you request court issues a court order to call a subpoena. That forces those people to come to court to testify for you if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. And that is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Right now, in the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof is on you to try to show you're not guilty, simply because you've been accused. In fact, under the law, you're not required to present any evidence at all. You may, but you're not required to. But whether you present any evidence at trial or not, the burden of proof remains upon the state of Ohio. Prove your guilt by proving beyond a reasonable doubt on every essential element of this offense, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally you pled not guilty, Mr. Hill. That plea denies the allegation in the indictment, denies you committed any crime, and that plea exercises or revokes all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegation in the indictment, admits that they constitute a crime, and is you're the one who committed that crime. And that plea waives and gives up all of the rights that I just described for you here today, except your right to have an attorney, which you always have, no matter what your plea. But with that exception, your plea of guilty would waive and give up your right to have a jury or court trial. It would waive and give up your right to cross-examine state's witnesses and confront them in open court. You would waive and give up your right to use the power of the court to compel the court witnesses being in court to testify for you, something like the state. You would waive and give up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. You would waive and give up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court if I think that's the right thing to do. And finally, it waives up on your right to file an appeal, which you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And you're a U.S. citizen, Mr. Hill?
Yes, Your Honor.
And you're entering into this agreement that I just explained to you voluntarily.
Yes, Your Honor.
Now, do you have any questions about the charge and the possible penalty?
No, Your Honor.
Understanding?
Yes, Your Honor.
Have any questions about the plea agreement?
No, Your Honor.
You understand?
Yes.
Again, you understand that the recommendation as to the sentencing is not binding on the court.
Yes, Your Honor.
Do you have any questions about the constitutional rights that I explained to you here today?
No, Your Honor.
Do you understand those?
Yes, Your Honor.
Do you have any questions about the plea of guilty, what it means, what the consequences of that plea will be if you enter here today?
No, Your Honor.
Do you understand?
Yes.
Is there anything you'd like to speak with Ms. Hackner about before we go any further?
Yes, we could.
Okay, let me put you in break.
Thank you. Thank you, Your Honor.
All right, no problem. Okay. Now, do you have any, questions about anything that I've explained to you here this afternoon, Mr. Hill?
No, Your Honor.
Then it's your decision to withdraw your not guilty plea and plead guilty to count 2, pursuant to the terms of the agreement that I've just gone over with you.
Yes, Your Honor.
All right, then as to the charge in count 2, which alleges that on or about December 8, 2019 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule 2 controlled substance with methamphetamine, an amount equal to or exceeding 3 times bulk amount, less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Revised Code. A charge of aggravated possession of methamphetamine, a third-degree felony, carrying possible prison term of between 9 and 36 months in the increments provided by law, a fine of up to $10,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. All right, the court finds that on this day, in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Police accepted order filed. Defendant is found guilty of the charge in count 2 as charged therein. The plea will be filed and accepted. Count 1 is hereby dismissed. Court orders the matter referred to the probation department for a pre-sentence investigation. And that would include the assessment for substance use disorder treatment of mental health, which is already being done. And bond will be continued. The hearing date will be October. Uh, 27th, Ms. Hapner, are you available? October 27th.
We've done ethics CLE that morning.
Okay. See what I have in the afternoon.
I have a 1 o'clock in juvenile court, but after that I'm free.
Okay. I have some others I sent, but I think they had to. I don't know what day I sent them. When did I send those other sentencings yesterday? October.
Okay.
Okay. Yeah, okay. That was the 21st, right?
Yeah,
How about the 27th in the afternoon?
it's not in the morning, that's where I moved it. 27th in the morning,
Yeah, good in the morning. She's got CLE.
Marnie,
Afternoon.
yeah.
All right. 2 o'clock. October 27th at 2 o'clock. Now I know there's a provision for in the plea agreement about referral to drug court. Where do you live, Mr. Bill?
We live in Montgomery County.
All right. Well, under the rules of the drug court, has to be a resident of Miles County or Norman County, so you wouldn't be eligible for our drug court unless you would move there. So.
And that's something we've been discussing, and discussing with Sturgill also.
All right. Well, if that's something he wants to do, that's up to him. I'm not. But
Sure.
if he's not, he won't be eligible. So,
Sure.
we'll get the other stuff done. All right. Thank you.
Thank you, Your Honor.
All right. We need to get a week bill now. He's not on yet. Follow it up here. Yeah, he's not in the police. Step off here for a minute.